Hello and welcome to the Herrington Carmichael Employment Law Update for July 2018. My name's Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and this month I've got 4 key cases to talk to you about. They're quite technical, so bear with me as we go through them. Let's start with the case of Reading Borough Council and James. This is an equal pay claim, and it's an equal pay claim over a long period of time. What the claimants argue is that historically their pay had been equalised with a male colleague some time previously. Then over a period of time the male's role changed. They argued their pay should have remained consistent throughout the period of time despite the changes in role by their comparator. Now what this means is effectively over a longer period of time people can look back and potentially compare themselves and try and claim equal pay through that comparison. What does it mean for you? It means you're going to have to potentially go back into more detail and you're going to have to dig in where there's a long-term equal pay claim being complained about. Second case this month is the case of Kilburn and London Borough of Wandsworth. This case relates to protected disclosures and what needs to be in a protected disclosure for it to be sufficient. In this case it was found that allegations alone were not a protected disclosure. There needed to be proper information included within the disclosure for it to be protected. Let me give you an example. If you complain about inappropriate behaviour, that's unlikely to be a protected disclosure under this authority, whereas if you complain about breaches of health and safety or breaches of the criminal law, that's likely to be a protected disclosure and therefore caught by the legislation. Third case this month is the case of Core and Leeds teaching hospitals. This case relates to constructive dismissal. Now, in a constructive dismissal claim, and the claimant is claiming that they've suffered a repudiatory breach which has given them the ability to resign and claim constructive dismissal. This case related to a last straw breach. So that's where there's been alleged breaches over a longer period of time and we've come to the last straw and the individual claims that that gives rise to the repudiatory breach. In this case, what it held was that final straw can revive previous repudiatory breaches even if the employer argues that that period of time caused the employee to accept those breaches. Now that's quite technical, so what you basically need to know is that in every case where you're looking over a longer period of time, you're going to have to look very specifically as to whether that last breach revives something which happened before. The last breach has to be something that is more than merely innocuous, so therefore it has to be something which is a bit more substantial. But again, it's going to be a very fact-specific case and something to look at quite carefully. Finally, the case of Herrington Carmichael and Borough. This case involves dismissals for serious misconduct. Now, you would know a dismissal for a gross misconduct gives rise to immediate breach. In this case, the employer dismissed for serious misconduct and was still able to dismiss with immediate effect without any form of warnings. Now this is an important thing to remember. In certain circumstances you're not going to be able to warn the employee, and actually an act of serious misconduct, which is not necessarily gross misconduct, will give rise to a dismissal situation. Of course the difference between serious misconduct and gross misconduct is that you would have to pay notice pay in a serious misconduct situation, whereas in a gross misconduct situation you wouldn't. That's it for me this month. I come back to you in August, and until then I hope you have a very good summer. Thank you.